The Supreme Court chamber was utterly silent. Chief Justice John Roberts, typically composed and restrained, slowly removed his reading glasses and leaned forward, his eyes fixed on Congresswoman Jasmine Crockett. What had begun as a standard hearing on voting rights was now transforming into a moment that would echo through legal history. "Congresswoman Crockett," Roberts began, his steady voice commanding the hushed room, "I must say, I have rarely encountered such clarity of thought under such rigorous questioning." A ripple of surprise swept through the gallery. The Chief Justice was not known for public praise during oral arguments, yet his respectful nod toward Crockett carried immense significance. In that instant, a first-term Congresswoman from Texas had earned the rarest form of acknowledgement, a gesture of respect from the nation's highest judicial authority. To understand the magnitude of that exchange, one must know the figures at its center. Chief Justice Roberts, born in Buffalo in 1955, has led the Supreme Court since 2005. A Harvard Law graduate and former clerk to Justice William Rehnquist, Roberts built a career as one of America's sharpest appellate attorneys, arguing 39 cases before the Supreme Court. Known for his meticulous reasoning and institutional caution, Roberts has long sought to protect the court's integrity from political polarization. Though appointed by President George W. Bush, he has occasionally defied partisan expectations, most famously when he upheld the Affordable Care Act. Facing him was Congresswoman Jasmine Crockett, representing Texas's 30th district since 2023. Born in St. Louis to a postal worker and a nurse, Crockett rose from modest beginnings to become a prominent civil rights attorney specializing in voting rights. Her deep understanding of how restrictive laws disenfranchise minority communities shaped her career, and now, her argument before the Supreme Court. The case, Henderson County Election Commission versus United States, challenged a state law that had closed over 200 polling sites in predominantly minority areas under the guise of efficiency. While the law never mentioned race, its implementation forced minority voters to travel 5 times farther than white voters to cast ballots. Lower courts had disagreed on whether this violated Section 2 of the Voting Rights Act, prompting the Supreme Court to intervene. When oral arguments began, the courtroom was packed with journalists, civil rights leaders, and legal scholars. Crockett entered in a plain navy suit, carrying only a slim binder. Her calm contrasted with the tension in the air. Roberts opened sharply. "Your brief claims this formula violates Section 2, yet the statute contains no racial language. How do you establish discriminatory intent?" Crockett's response was poised and precise. "Mr. Chief Justice, under Village of Arlington Heights, the court evaluates discriminatory intent by examining history, procedure, sequence, and impact. All 4 point unmistakably to intent here." When Justice Alito challenged her, she countered firmly, producing an internal memo from the state's own files showing awareness that the closures would suppress turnout in minority-heavy Democratic areas. Justice Kagan pressed her on the state's claim of budget constraints. Crockett noted that $4.2 million had been allocated for polling sites in white rural regions at the same time. Finally, Justice Gorsuch questioned whether her reasoning defied textualist principles. Without missing a beat, Crockett replied, "Textualism does not require blindness to context." The courtroom held its breath, and in that silence, Chief Justice Roberts, protector of decorum, skeptic of theatrics, nodded in acknowledgement. History, it seemed, had just witnessed the making of a new legal voice for democracy. In Village of Arlington Heights, the Supreme Court recognized that even facially neutral laws can conceal discriminatory motives. Congresswoman Jasmine Crockett invoked that precedent with unwavering confidence as she faced a barrage of questions from the nation's highest bench. "The text is crucial," she began, "but the Constitution prohibits both overt and subtle forms of discrimination." Justice Neil Gorsuch leaned forward. "Then where do we draw the line? How do we determine when disparate impact becomes discriminatory intent without replacing legislative judgment with our own?" Crockett didn't hesitate. "The line, Justice Gorsuch, is drawn by the evidence. Here we have contemporaneous statements from officials, rejected alternatives with less disparate impact, and procedural irregularities during adoption. These are the very indicators this court has long recognized as evidence of discriminatory intent." Justice Brett Kavanaugh shifted focus. "Let's discuss remedies. If we were to find a Section 2 violation, what would be the appropriate remedy? Wouldn't we risk judicial policymaking by dictating polling site locations? Not at all, Justice Kavanaugh. Crockett replied evenly. The remedy would merely require the state to adopt a formula that does not impose disproportionate burdens on minority voters. The state retains full discretion in determining how to comply. Courts have implemented similar remedies for decades without engaging in policymaking. For 40 minutes, the questioning continued relentlessly. Justice after justice pressed her, but Crockett countered with constitutional precision, precedent, and empirical data, anticipating every challenge. Justice Amy Coney Barrett raised a historical point. Congresswoman, how much weight should we assign to a state's history of discrimination when evaluating a modern, facially neutral law? When does history become too distant to matter? Justice Barrett, Crockett answered, history matters most when its effects remain measurable. In this case, historical housing segregation directly correlates with current residential patterns, which determine which communities bear the burden of these closures. This is not distant history. It is ongoing causation. Then came the exchange that would be studied in law schools for decades. Chief Justice John Roberts posed one of his famously difficult hypotheticals. Suppose a jurisdiction adopts a race-neutral formula, one polling site per 5,000 voters. If minority neighborhoods end up with fewer sites due to lower registration rates rooted in historical discrimination, would that trigger strict scrutiny under your theory? The chamber tensed. Crockett paused briefly, then spoke with deliberate calm. Chief Justice Roberts, that is what scholars call second-generation discrimination. Policies exploiting existing social patterns to produce racially skewed results. Under Arlington Heights and Brnovich, we ask whether officials knew or should have known of these disparities and proceeded anyway. If so, intent could be inferred, justifying heightened scrutiny. Roberts pressed again. But where do we draw the line? Couldn't any election decision be challenged if it shows disparity? The line, Mr. Chief Justice, Crockett replied clearly, lies in the faithful application of Arlington Heights. Not every disparity proves discrimination. Some outcomes are unavoidable. But when a state knowingly adopts a method that imposes severe burdens on minority citizens despite less discriminatory options, the Constitution cannot remain silent. As she spoke, the courtroom remained utterly still. The 15th Amendment, she continued, was never meant to ban only explicit racial bars. When modern laws reproduce the same outcomes as poll taxes or literacy tests, they must face the same constitutional reckoning. Even Justice Clarence Thomas broke his usual silence. Congresswoman, what evidence suggests intentional discrimination rather than neutral efficiency? Justice Thomas, Crockett replied, the state's own data showed these closures disproportionately affected minority voters. Meeting minutes reveal officials dismissed those concerns, saying, we can't be responsible for who chooses to vote. And crucially, these closures followed record minority turnout. That timing, under this court's precedents, is powerful circumstantial evidence of intent. Thomas nodded slightly. The room remained hushed. In that moment, even the most skeptical justices recognized that Congresswoman Crockett had not merely defended voting rights. She had defined them anew. The state's alternative plan, known as Plan C, had promised the same cost savings while reducing the disparate impact on minority voters by more than 70%. When such alternatives exist, Congresswoman Jasmine Crockett concluded firmly, a state cannot claim that discrimination is the price of efficiency. As she finished, Chief Justice John Roberts sat motionless, his expression thoughtful. The rapid rhythm of Supreme Court questioning gave way to a rare, almost reverent silence. When the state solicitor general approached the podium for rebuttal, it was clear the momentum had shifted. One by one, the justices pressed him on the evidence Crockett had presented, particularly the rejected alternatives and internal communications acknowledging partisan consequences. If your state knew these closures would disproportionately burden minority voters and had other plans that achieved equal efficiency without such harm, Justice Sotomayor asked sharply, why were those alternatives rejected? The Solicitor General faltered. The statute contains no racial classifications, he insisted. Courts must be cautious before inferring intent from disparate impact alone. Justice Kagan interjected immediately. But we're not talking about mere disparate impact. Congresswoman Crockett presented memos acknowledging racial effects, testimony on rejected alternatives, and evidence of procedural irregularities. How do you address that? Those were preliminary drafts, Your Honor, he stammered. They do not reflect final deliberations. Justice Barrett leaned forward. But they do show awareness of the likely impact. Under Arlington Heights, doesn't that awareness become legally significant? Visibly unsettled, the Solicitor General attempted to recover. Even if a Section 2 violation were found, he said, the remedy should be limited to affected districts, not the entire state formula. Chief Justice Roberts, usually deferential to state officials, intervened with unusual directness. Counsel, you have not addressed Congresswoman Crockett's evidence that your state was warned of the disparate impact, yet proceeded without exploring less discriminatory options. How do you reconcile that with your claim of unintentional consequences? Mr. Chief Justice, the Solicitor General began nervously, election administration involves trade-offs. The legislature weighed factors not reflected in the record. Justice Kavanaugh pressed him harder. Did those factors include consideration of which voters will be most burdened? No, Your Honor. The formula was based solely on efficiency. Justice Gorsuch's tone was pointed. Then if efficiency was the goal, why wasn't Plan C adopted? It achieved the same results with far less harm. The Solicitor General hesitated, fumbling through his binder. I do not have those specific details before me. His argument collapsed under the justice's scrutiny. Even those expected to favor the state now appeared skeptical. Then Justice Clarence Thomas, who rarely spoke during oral arguments, posed a question that would define the day. Counsel, he asked quietly, if we accept your argument that only explicit racial classifications trigger scrutiny, do we not hand states a roadmap to evade the 15th Amendment through neutral laws with known discriminatory effects? The courtroom froze. The Solicitor General faltered, mumbling about the need for proof of intent. And is that not exactly what Congresswoman Crockett has provided? Thomas replied evenly. Internal communications rejected alternatives and a clear historical pattern. Unable to respond, the Solicitor General sat down. Crockett rose for her closing. The question before this court, she said steadily, is whether our Constitution permits states to do indirectly what they cannot do directly. The evidence shows the state knew its formula would burden minority voters, rejected fairer alternatives, and proceeded anyway. She continued, throughout our history, from poll taxes to literacy tests, methods have changed, but the intent has not. This case is not about efficiency. It is about equality. The 15th Amendment guarantees every American the right to vote, not just in theory, but in practice. When she finished, Chief Justice Roberts removed his glasses and looked directly at her. Congresswoman Crockett, he said solemnly, I must say, I have rarely encountered such clarity of thought under such demanding questioning. Your presentation has been a model of constitutional advocacy. Crockett inclined her head. Thank you, Mr. Chief Justice. But what truly matters is whether this court will ensure that every citizen's right to vote remains free from discriminatory barriers. Her words hung in the air, followed by Roberts' quiet nod, an unspoken acknowledgement that something historic had just taken place.